Some more typical contract clauses. At the beginning of most commercial contracts, there are sections that deal with information such as the names of the parties, the background to the contract, and the definite terms. After these sections, you will find the main body of the contract. The main body of the contract is made up of clauses. There are some types of clauses that you will find in most commercial contracts. A commercial contract usually contains, for example, a clause that states what the term of the contract will be. The term of the contract is duration of the contract. It means the period of time for which the contract is valid. There will also be a termination clause. This clause contains information about the expiration of the contract. Expiration means end, so the agreed date of expiration of a contract is the agreed date upon which the contract will end. A contract of employment, for example, might have a term of 1 year. The termination clause tells the employer and the employee how the contract can end after a shorter period of time before the agreed date of expiration. There is often a clause in a contract that deals with information that must remain secret. This clause usually obligates one of the parties to keep confidential certain information connected with the other party. For example, let's say an advertising company enters into a contract with a drugs company. The advertising company agrees to create an advertising campaign for a new kind of medicine that the drugs company produces. The contract will include a clause that obligates the advertising company not to tell or disclose certain information to any third party about the drugs company's products, production methods, or financial information. This clause is often known as the confidential clause or the non-disclosure clause. Many modern contracts also have a clause that deals with intellectual property rights. This is very common in contracts under which someone such as an author or self-employed freelance designer produces creative work for a third party such as a publisher or a company. For example, Mary is a good artist. She designs birthday cards for children. The Sleeping Beauty card company commissions Mary to create 2 new designs. To commission someone means to formally ask that person to do something or produce something, usually of a creative nature. The contract should make clear who is the owner of the design after the company prints the cards. Is it Mary or is it the card company? Can the card company use Mary's designs on other goods? The design is intellectual property and it can be very valuable. Most contracts make clear who has copyright in intellectual property. To have copyright in a design, for example, means that you are the owner of the design. I hope you enjoyed this video. I put a lot of legal information that you need to expand your legal knowledge. Please subscribe to the channel and turn on notifications to listen my next podcast first. Thank you for listening Moral Advocate YouTube channel.